Google Hangout. Today it's me, Lumi, and my colleague Steve.
Hi.
We're happy to have you live with us. Thanks for taking time on a Thursday morning to join in. Today, actually, before we get into our topic, let's explain for those who are new in the audience what our Google Hangout is, what the purpose is, and how it's meant to unfold. Google Hangouts here are meant to be a tool for us to educate people about employment law. We want to discuss various topics that are relevant to everyday people. We're meant to be very practical in our choice of topics, in the way we discuss our topics, and so don't hesitate to ask questions along the way. Hopefully, again, the topic that we picked today is you'll find it interesting, and it'll result in questions from the audience. Feel free to tell your friends and colleagues about us. And again, thank you for attending. One other thing before we start, please don't take, I'm sure you already know this, but please don't take what we say today as legal advice. It's only meant to be general information. Everybody's circumstances are unique, and so if there's a particular scenario or case that you want to discuss, or if you want to discuss your particular situation with us, call in. I believe there's a number on our on the website, and so call in, and we'll discuss your particular situation. In any event, for today's purposes, we're going to discuss, the topic was advertised, it's termination entitlements for short service employees. And in employment law, the general rule is that in the absence of a contractual term that limits somebody's termination entitlement, an employee, a departing employee, whose employment is terminated on a without cause basis, is entitled to reasonable notice based on a number of factors, such as length of service, age, character of employment, and availability of replacement employment. That said, it's also true that short service employees generally tend to get disproportionately lengthy notice periods, or they're entitled to disproportionately lengthy notice periods. And so we're going to address those situations today. We're going to go over some scenarios for again, short service employees that in theory are entitled to lengthier notice periods than it's intuitive.
Well, and I think the important thing, and we get questions every day, and so people might think, well, I'm owed 2 weeks a year, or it's a month a year, and not that any of those assumptions are wrong, but it depends on the specific circumstances. So, well, a short service employee, and we'll talk about this a bit more, might get, for 1 year of service, might get 6 months of severance, whereas you know, it disproportionately changes as you have longer service. So it's always important when you're terminated to get legal advice, and you know, you might find that you're entitled to much more than a month a year, or much more than a week a year.
And so really the takeaway message is that short service does not necessarily preclude a significant notice period. And actually, as I was preparing for today, I came across something that one of the judges who specializes in employment law, said, I'm talking about Justice Sproat, and he said that any real job can be expected to take at least 3 months to replace. And so there's, I guess, general understanding in the employment law bar, amongst employment lawyers, that that's 3 months seems to be, I guess, a soft floor for reasonable notice.
And certainly it could be much, much more than 3 months, but you know, that's to say it's not just long service employees who receive lengthy notice periods, because we're just, the law is trying to figure out the length of time that it takes for you to find another job. And it just because you've been somewhere for 6 months, it doesn't necessarily mean it's going to take you a shorter period of time to replace that employment.
So let's discuss some specific scenarios.
Sure.
And I think a good place to start would be the rules that apply to executive employees, senior people whose level of compensation is above average. So
sure. And the important thing, and so what I'm going to say next applies to executives, but it also applies to all employees who don't just derive their income from an hourly rate of pay or a salary. So what I mean by that is executives normally aren't just paid a base rate. And so sometimes there's a lot of different components that we need to look at for executives. Or, you know, an example might be that I came across recently an employee who derives half their income from a commission and the other half from a salary and has bonuses. So you might receive a fair severance package, but it's always important to look beneath how many months are being offered and see if all components of compensation are provided. And this is something that's very important for executives. And like I say, employees who have income that comes from different sources at the same job. So when looking at executive positions, the first thing is to say is look at all components of compensation, because when we talk about severance specifically, we talk about all components of compensation, not just your salary being continued. And in the case of an executive, there'll be a lot of components, and you want to make sure all of them continue throughout the notice period. As well, and something we have noticed quite a lot in recent years is that executives, even if they're short service, receive lengthy notice periods. The law recognizes it's hard for an executive or a high-ranking member of an organization to replace that job. It's not as simple for an executive to go out and replace the employment. So, you know, it's always important to first look at the components of compensation, know that you are entitled to severance, which might be or often is lengthy.
And the other point that we should probably make in this that applies to again, senior employees who have been with their employer for a relatively short period of time, a few months or maybe no more than 2 years, they do get disproportionately lengthy notice periods. And there are numerous examples of executives with just, again, a few months of service, and they get more months of notice than they have months of employment, and that is true across the board. And that speaks to character of employment, which is one of the factors that courts take into account when they determine the appropriate length of the notice period. And so calculating the number of months is an art more than a science. And really, it all comes down to how easy it is to replace a job. And simply because you work in a certain for a certain organization for less than a year doesn't mean that it's easier to replace that job than if you work for let's say 5 years. And so it also goes back to one of the main tenets of the concept, or the main presumption behind the concept of reasonable notice. Reasonable notice is meant less as a recognition of service as it is meant as assistance while an employee whose employment was terminated, how long he or she needs to, again, reasonable notice is meant to function as assistance for while someone is looking for another job.
Absolutely. So, I mean, why don't we talk next about highly skilled employees? We touched on short service employees and executives, and there's some common themes. But what if you're someone who has a job that's specifically tailored to the operations of a business, highly skilled, and skills that may in some circumstances not be transferable? How are those employees treated?
The example I always like to give, and there are actually many cases with this scenario, is, for example, a physicist or an engineer who specializes in the nuclear or atomic industry, right? And so obviously there are like the jobs, the applicable jobs are few and far between, and there are only so many nuclear plants in the province. And so for someone who has niche expertise, such as a nuclear physicist, for example, it's obviously going to be very difficult to replace his or her job. And so obviously, even with short service, someone, again, with very niche expertise, and again, it doesn't have to be as specific as...
Not just physicists.
Not just physicists, but again, special engineers, special IT employees, employees who specialize in specific software that has very, very narrow application.
And I think the important thing is it's not just employees who are specifically trained as, let's say, a physicist. It's also employees who are trained specific to the company, and those skills aren't highly transferable to another job. So recently, I spoke with an individual who worked for a large telecommunications company, and that individual was working only with the software and systems of that company, and other companies didn't really have comparable positions. The job itself, while highly skilled, was also unique to that employer. And what we were able to say in negotiating for that individual severance is that the skills that individual had gained from that position weren't highly transferable, and there weren't comparable positions. We were able to negotiate for a very fair severance period and a lengthy severance period based on the fact that that employee had specific challenges going forward into the employment market.
Why don't we address or answer one of the questions that we just got from our audience? And the question comes from a sales representative working on commission, who has a very narrow specialty. He sells very specific products, and he just lost his job, and he is concerned that the skills that he has in terms of, because his sales expertise is very, very restricted to a particular set of products and is not easily, can't easily translate into other types of sales, he is wondering what the notice period would be for him. And I believe he has 2 months of service only. He was terminated very shortly after being hired, and he is 50. What do you think?
Well, in this case, you know, and in any case, we look at 3 predominant factors: age, length of service, and position. And in looking at those factors, it's going to be first harder for that individual to find a position based on age, but also, and I think goes to the question that we have, is the specific nature of the work that individual does will certainly lengthen the notice period. And the fact that this individual's only been there 2 months doesn't necessarily mean that they get a limited notice period. This is someone who might get as much as 6 to 8 months of notice when looking at the statistics, or when looking at the character of their employment, their age, and service that they provided.
So really, it all comes down to being able to prove that the employment opportunities available for you are very, very limited. And so list of companies who sell the same types of products, what makes that product special, and what distinguishes that product from the other ones, which makes your sales expertise difficult to translate to other fields. Again, it's a case that really comes down to evidence.
Yeah, and it wouldn't be a case where it would just simply be sales jobs. This individual, although we don't know the specifics of their job yet, wouldn't be able to go and just take another sales job, and it's going to take a while to apply those skills and find a specific position that's comparable. So, you know, anytime you're terminated and you work in a highly technical, highly specialized, or even in a position that is unique to your employer, you know, it's important that you reach out and talk to one of us, and as advocates, we bring those facts forward to the other side. It's very important in any of those circumstances to give us a call.
Another example that comes to mind is someone who works for an industry that is in decline, let's say the energy sector. And so there's recognition that probably if there isn't a hiring freeze, at least employers are very apprehensive about bringing new people on board. And so again, longer termination entitlements are triggered in that scenario.
Well, and I think it's very similar. So if you're someone who works in an industry that for any reasons is in decline, or the skills of sometimes a person isn't needed. So what do I mean by that? I recently spoke to an individual who worked in the printing industry, and for years now, well, technology is great. It's also led to replacing employees with machines, specifically in the printing industry. And I spoke to this individual, and for most of his adult life, he had worked specifically in printing. Not surprisingly, there's no availabilities for printing pressmen, or at least very limited abilities. And that was something we were able to bring forward to significantly lengthen the notice period. So if you work in an industry in decline, if your job is specifically tailored to the operations of your employer and not highly transferable, or if you're in a highly skilled area, it's really important, again, if you're terminated, to give us a call or seek legal advice, because those are factors that need to be brought to the attention of your employer in order to advocate for a greater notice period.
Back to the example of software specialist. One of my clients specializes in a very archaic software that I believe was very popular in the 90s, and some firms still use the software, but they're phasing it out. And so he was hired at the beginning of the year to maintain the database that was running on that particular software, but in the end, the employer decided to simply discontinue that database. And so in that case, my client, again, with just a few months into his employment, lost his job. And so he was hired for a very specific area of expertise, but that only applied to a very archaic software. And so in that case, we were able to secure quite a lengthy notice period, again, because of the facts, because of the unique circumstances of my client's expertise and the fact that it didn't match what the job market is currently asking for.
So we have another question, and what's written here, and what the person is asking is, I recently left my position to go to an employer, a new employer. They had, and she says that they had recruited her into that position, and she was terminated 3 months after she started. And she wants to know what impact, if any, that might have on her severance. And that's a really good question, because a lot of times employers will use recruiting agencies, or themselves will go out and recruit talented employees to come work with them. And Lumi, I mean, I often see this, and I'm sure you do as well, that in certain circumstances the job doesn't work out, and the individual is left after leaving a lengthy career, terminated after 3, 4, 5 months, or a very short period. So what remedy, if any, is there? And the answer is, in specific circumstances where you have been recruited or induced to leave your job, we can recognize the service from your past employer in calculating the notice period. And that's really important, and that's something a lot of times people feel, well, I've left this great career, I've went to a new employer, it didn't work out. Sometimes things don't work out, and now in calculating the notice period, we can look to the service that you had with your previous employer in calculating the notice period and advocating for you. So it's important, if you've been recruited to leave your job or induced to leave your job, that you seek legal advice, because a lot of times your employer won't recognize, or actually not a lot of times, almost in all circumstances, your employer will not recognize your past service.
Yeah, and it's true that courts, like in the scenario that you described, they don't look at this individual as a short service employee. They don't look just at the months of service with the last employer. They look at the cumulative length of service, including the previous employment. Again, assuming, so we're not dealing with short service. Like it's like the court is not dealing with a short service employee, it's dealing with a long service employee. Again, the evidence has to be there that, for example, the individual was not looking for a job, did not have his or her resume out there, he or she was not circulating her resume, and he or she was actively courted by the most recent employer.
So often, and this brings us to another point, because we talk about being terminated early on into a new position or any position. What happens? I mean, a lot of people ask, during that early days of employment, isn't there a probationary period? A lot of people will look at the Employment Standards Act and see a 3-month probationary period. So, Lumi, I guess my question is really, what happens when you're terminated 2 months into your employment, or what happens if there's a probationary clause? Does that mean you don't get severance? And that's a question we get a lot.
Whether it's a formal or informal probationary term, as long as the fact that an employee is on probation, that is relevant, but because it does speak to the intention of the parties at the time they decided to go into this employment relationship. And so back in the day, an employee terminated during his or her probationary term was not entitled to significant notice, if any, but that view has changed over the years. And so the predominant opinion now is that somebody who was hired even on probation must be given opportunity, a fair opportunity to prove himself or herself. And must be given reasonable opportunity to demonstrate the ability to do her job. In the absence of fair treatment during the probationary term, an employer opens itself to significant liability. There's a very good case in terms of facts. An accountant was hired at an accounting firm, and with, again, the understanding was that there was a 3-month probation period in place. 1 month in, he loses his job, he sues, and then he gets 4 months of notice from the court. Again, the idea being that in that case, the employer even took the position that the employee was not a good fit. In court, the employee was able to prove that his ability to do the job was not properly measured, monitored, and therefore determination was done in bad faith. And so again, 1 month of service leads to an award of 4 months of notice.
So what we're trying to say is, if you're terminated during a probationary period, or if your employer says to you, listen, things aren't working out, we tried this. I mean, there could be a number of reasons why it's important to get a second opinion. If you've been induced away from another job, if you were terminated without any severance on account of being within the probationary period, there's a lot of opportunities to make sure that you receive reasonable notice and reasonable severance. So it's important in any circumstance to get a second opinion.
Somebody's bringing up a very interesting scenario, a combination of inducement and with a probationary term. So basically, this person was actively courted to leave her job, but she also signed a contract that has a probationary term in it. And so the answer is really that the fact that there is a probationary term that is in writing tends to cancel out or invalidate the inducement argument. You can't really say that you were under the understanding that the employment was secure in the long term when you agreed in writing to a probationary clause.
But even if you've signed a contract that says there is a probationary period, I think it's still important that you receive a second opinion, because sometimes probationary periods, and we see this often, are lengthy, 6 months, 12 months. There still has to be a reasonableness aspect to any probationary period. It's important that anyone who is terminated within a probationary period give us a call.
And don't assume, don't make assumptions about the notice period. Don't make assumptions about the enforceability of a contract that you signed. Don't make assumptions about the enforceability of a termination clause that you signed. There are ways to limit, for employers to limit their liability in the event they terminate an employee during the probationary term. That said, the language in the contract has to be very specific. It's very technical, and we specialize in drafting contracts with probationary clauses in them, and we specialize in attacking contracts when we act for the employees.
Absolutely. And so it's always important, whether you have a contract, whether you believe you've received fair severance. It's always important, if you're a short service employee, someone with a contract, to get a second opinion and really have someone who specializes in this take a look at all the material that relates to your employment and the character of your employment to make sure that you're receiving reasonable severance.
We don't have a lot of time left, but Steve, do you want to maybe speak about the effect of a non-compete or non-solicitation clause has on your on termination entitlements.
Sure. A lot of times, and this is very common, an employer, and it can happen at two times. Sometimes when you initially sign a contract, and what Lumi means by a non-solicit non-compete is something that bars you from working in your industry with a similar employer, a lot of times with a competitive employer. And you might sign this contract when you begin your employment, but your employer might also ask that you sign a non-solicit non-compete at the time of termination when you're being provided severance. It's really important, if you're being asked to sign a non-solicit non-compete at the beginning or end of your employment, to give us a call, because this might have pieces for your employability in the future. And a lot of times when you go to a new employer, they'll want to know if you've signed on to any type of clause like this, because restricting where you work will always impact the negotiations. And a lot of times employers have asked clients of mine to sign on to these clauses, and we've been able to negotiate to remove those clauses. Again, very important, if you're ever being asked to sign a non-solicit non-compete or any type of clause that restricts your employability, to give us a call and get a second opinion. Throughout
our discussion today, we mentioned reasonable notice and the common law. And so to conclude our matter or our discussion today, I was going to say that it's easy for employers to limit their liability and avoid having to pay reasonable notice or having to provide reasonable notice at common law. Those, like the right to reasonable notice at common law can be replaced with contractual terms by I guess what I'm trying to say is that employers are able to limit their liability and limit their employees' termination entitlements with well-drafted contracts that contain enforceable termination provisions. So just to give extreme examples, you can reduce someone's termination entitlements from 24 months to 8 months, to 8 weeks actually, again, provided that you have a good, well-drafted contract in place. And so there are ways to reduce liability for employers when they hire people and when they don't know how things will work out and whether the employee is a good fit or not. And so, again, there are ways that liability and termination entitlements can be limited, but the language has to be very, very specific and very accurate in order for it to be held enforceable. So again, we specialize in this area of law. Call us, email us, post your questions, or contact us on the website, and we'll happy to assist you.
Absolutely. And before we go, if you're ever wondering what your notice period might be, visit the severancepaycalculator.com. Very important tool, and a tool that we're very proud of at this firm, where you're able to go on and within minutes find out what the reasonable notice period is. And we also have employer questions as well. So the website's severancepaycalculator.com. Please visit it. There's an app for your phone which you'll be able to add, and that way you always know what your reasonable notice period is at termination.
And with that, we will end today. We will see you in 2 weeks. Again, there are multiple ways for you to reach us. Take advantage of those values. So again, we wish you a great end of the week, a great weekend, and we'll see you in 2 weeks.